Order, order. Can I welcome our witnesses to our first evidence session on the short inquiry we're doing on the changes to immigration status that the government has announced. We are looking into what we can feed into the consultation, and we're very grateful to have a panel to start with to give us a background and briefing on the situation. And perhaps if I can start at that end and ask the panel to introduce themselves, and then we'll go into questions.
Thank you, Madam Chair. I'm Nick Rollason. I'm the Head of Immigration at Kingsley, Napley, a London law firm.
Thank you.
I'm Alan Manning. I'm a Professor of Economics at LSE and also an ex-chair of the MAC.
I'm Madeleine Sumption. I'm Director of the Migration Observatory at the University of Oxford, also Deputy Chair of the MAC.
Thank you very much. We're going to start our questions with Ben Maguire.
Thanks, Chair, and thanks all our guests for coming in today. We're obviously looking at the settlement proposals that the government have announced, and I was keen to hear what you think are the main objectives that the government are trying to achieve with these planned changes to settlement, first of all.
Yeah, I mean, I think the consultation is not that specific on the aims of the particular measures, which is not unusual for a high-level political document, but I do think when scrutinising them, it's useful to think through exactly what kinds of things the government is trying to achieve. I see basically four main goals of settlement policy. So the first is basically selection. So you're saying, is someone comes in on a particular visa, but the government might want to make sure that they're still eligible over time. So if they had permanent status immediately, then if they lost their job, the permanent status is the last point at which you're making that decision. So you might want a track record of a few years to make sure they stay in employment or similar. There's no evidence, I think, on what is precisely the right duration for that to get that kind of track record. Although 5 years tends to be pretty standard across a lot of countries. The second is if temporary visas allow the government to restrict rights in a way that may reduce some costs of migration, at least for certain groups. So obviously, traditionally, restrictions on welfare benefits has come as part of the package as being on a temporary visa, payment of immigration fees, which changes the economics of those visas. That doesn't necessarily have to be attached to the temporary visa versus ILR distinction, but traditionally it has been. The third goal, I think, potential goal is to incentivize integration-related behaviours, like, for example, learning the language or entering employment. And I think that, for the most part, the duration of settlement doesn't really do this. In fact, it might have a negative impact, as I suspect we'll discuss. The criteria for settlement may well have an incentive effect. For example, although we can look in detail at the specific criteria, a lot of the criteria are not the kinds of things that people control. People can't just decide to get a job earning £50,000, for example. You don't have the qualifications for that. But in theory, you could see some kind of incentive effects based from the criteria. And then the last one is to kind of change the attractiveness of the country. Typically, when people talk about settlement and attractiveness, they're usually talking about a shorter route in order to attract particular people, but the government might want to deter people through a longer route. There isn't a lot of evidence on whether that happens in practice, and it's actually not clear from the consultation document whether that is in fact the government's goal. But those, I would say, there might be something I've missed. Maybe Alan will have other ideas. But I think those are the main goals. And then if you look at the different criteria, I think it's useful to think, are they actually achieving them, which I'm sure we'll discuss in the rest of the session.
I mean, I agree with that. I would just sort of add one thing. I mean, the consultation is called a fairer pathway to settlement. So there's this idea that, settlement is a privilege, not a right, that if we're giving people settlement, it's unreasonable to expect that they should have given us something in return, both in the past or likely in the future. And the implication, I think, of the document is the feeling is that in some cases not enough has been asked under the current system, so that balance of contribution relative to right is out of balance. I mean, I think that's the government's perspective on this.
And if I could just follow up, do you think these proposals that have been announced, and just more generally in terms of making settlement routes more difficult, do you see that as impacting migrants leaving the UK or even not coming to the UK? I'm just particularly mindful. I had some constituent casework last week where a married couple living in the US hoping to come back to the UK to settle, but my region of Cornwall obviously has a lot lower salaries than other parts of the UK, so that salary threshold, as an example, was particularly difficult for them to meet as a household income target. So do you see any of these proposals as either having an effect on migrants leaving because they just see it as too difficult to get their route to settlement, or as a deterrent as well?
I think that's very difficult to predict, and different groups are likely to respond in different ways, not least obviously they will face different actual pathways to settlement. But you have specific situations. So in the care sector, for example, I think that's one of the areas where if you're looking at people, either people already here or people who might be considering switching into the care sector as an international student, which is obviously still possible. If you're talking about jobs that people didn't really want to do, but they were doing it in order to get settlement, there's a big difference between having to do that for 5 years and having to do that for 15 years, for example, in the care sector. I think in other cases, if you've got a highly skilled worker who's actually quite happy doing that job for a long period, it may have they're less likely to be subject to the rules, and it may have less deterrent effect, although obviously the more highly skilled and highly paid someone is, the more options they have. And so it's possible that you might get some deterrent effect, particularly from, if you look at highly skilled workers, the mandatory requirement for spouses may make an impact, right? Does the sort of, CEO of some tech company is his partner going to have to go work in a minimum wage job part-time in order to be able to meet the settlement requirement? That could potentially be quite unattractive. But I think broadly speaking, it's just really hard to predict precisely how people are going to respond to these rules.
I think the reality in many of the jobs is that the world is very unequal. So there are far more people who want to migrate than are being allowed to migrate. And so that, although there are cases where migrants who are sort of shopping around for the best deal, most people who want to migrate don't have multiple offers. They're taking the offer that they get. And so places like the UAE or Singapore offer much less attractive deals, even under the government's, proposals, and yet are still managing to recruit, large numbers of people. So I think, although there are individual cases, I don't think in the big scheme of things this will make that much difference. I
should say I agree with that, actually. I cited those cases because I think there are exceptions where we might see an impact, but I think most people will stick it out. That would be my suspicion.
Okay, thanks. So just the final point to close in, following up on all of that, do you see any particular group being deterred from coming to the UK and seeking that settlement status, or is it too early to say based on what we've seen so far?
I don't think I have any particular suggestions.
You mentioned earlier, Dr. Sumption, about the skilled workers have obviously more options. Does that imply that those set of workers will be less deterred to come here, and other less skilled workers will be more deterred?
It's tricky to say, because actually a lot of the high skilled workers, the people with most options, often don't come thinking, I'm going to move to the UK, this is a permanent move. They might come and they say, oh, this is an interesting job in the tech sector or whatever it is. And then they decide, and they say, maybe I'll do it for a couple of years, and then they make the decisions later once they're already here. I think it's the people who are most set on getting settlement who move, knowing that settlement is very important to them and they want this to be a permanent move, are probably also the people who are less likely to be deterred by a longer pathway to settlement.
Can I just also add that I think that anybody who's going to be paid less than this around £50,000 and won't qualify for 10 years, our clients who are hiring people and moving people in to the UK, from all over the world, are saying that will be very, very unattractive to tell their employees that they're going to have to wait 10 years for permanent residence. And part of that is to do with children, access to education, all the other things that you will probably talk about a little bit later. But it's also because global mobility programs for people on those levels, often they're paid more than that, working in large corporates, but they are well informed about what the relevant rules are in each country. And people often ask them, well, I'm going to this country, what's the deal? When will I get citizenship? If you're blocking people from getting permanent residence settlement, you're also blocking them from getting citizenship. So I do think there is a level of discussion which we see amongst clients at a real level, which is taking place, and it is concerning employers. In addition, employers are also saying that the requirement to have to sponsor people and keep them in sponsored employment for very long periods of time is also making hiring foreign talent very unattractive in some cases, unless they're paid, these higher amounts. So, there are winners and losers in this, and the migrants themselves may have less information, but employers are really having to think very carefully about what they do. And it's not just about people coming to the UK. Remember, we have a whole bunch of students here who can transition into sponsored work. If they are going into entry-level jobs out of university and being hired in graduate roles by companies, those employees will be at lower salaries for quite a long time, and they will not be able to count any of that time towards permanent residence, which means that those employers will have to sponsor them for a very, very long time. So hiring graduates in the UK is very unattractive now. It's already unattractive because the salaries are very high, but it's going to become even more unattractive for employers, which is going to affect migrants' choices potentially about coming to study in the UK, which also has a knock-on effect on other bits. So I think it's important to see that it's not just about the choice of going to A to B, from A to B. It's a number of different choices for employers and for migrants themselves, and it involves people who are coming here, but people also already here.
Thanks.
Ms. Murray.
Thank you. Thank you for coming in. And just a few follow-up questions from me. And just before we begin, can I declare the support my office receives from RAMP? So one of the things is that net migration has been very high in recent years, over the last decade. It's obviously coming down now, but it sort of peaked at around 900,000 net migrants a year. How far do you think that was influenced by UK settlement policy and the deal that we offer migrants who come here?
Decrease in net migration?
Increase or decrease? What's the influence of settlement policy on net migration?
I would imagine not very big. I think, it's obviously very difficult to predict for the reasons that we've just been discussing. A lot of it, so international students was one of the big groups that drove both the increase and also now via emigration is driving the decrease. And while many students are interested in settlement, they also, I think, are not necessarily looking that far ahead. And in fact, there's some research that the Migration Advisory Committee did that suggests actually people are often a bit over-optimistic about their chances. They assume that they're going to be able to sort out some kind of visa and don't necessarily realise actually sometimes they're quite surprised when they can't. And then you had other routes where it was quite uncertain whether people, obviously if you look at Hong Kong BNOs, for example, I think settlement you would expect, we know that a very high share of people expected to apply for settlement and that they were seeing it as a permanent move. If you have Ukrainians, that was another of the groups driving the change. The settlement situation is still very, very unclear for them. Care workers, obviously, if you think about the other groups that led to that increase and then the decrease, that would be a case where I think settlement probably was important, partly because of this phenomenon of a lot of people who don't necessarily want to work in the care sector long term, but saw it as a route to something else. So I think it varies. I think overall settlement policy certainly changes in settlement policy were not on the agenda at all, although some people would have factored in an understanding that they could get settlement.
Okay, so it sounds like you're saying that regardless of, even if a government really toughens settlement policy, it shouldn't expect to see a corresponding decline in migration.
Well, in some groups it might. So if you have a group of people who are coming in with the knowledge that they would, certainly if you took away the right for settlement entirely, so if you turn it into a temporary visa, then I think that would significantly affect the attractiveness. Yeah. Obviously the care sector, the care route is now closed for overseas recruitment anyway, but I think that would have played a role there. I think we don't have a lot of evidence, but the very limited evidence we do have suggests that the difference between a sort of faster and slower route to settlement for a lot of workers doesn't make a huge amount of difference. There's an experimental survey study that found that, but I think it's just very uncertain in this area to work out, how much quantitatively how much impact would this have.
Okay, thank you. Just a couple more questions. So one of we're talking about the purpose and the aims of earned settlement. One of the, let me test a hypothesis on you, see what you think, right? A government has very few levers to influence behaviour of people in the country, right? We've got the education system, and we can, teach people English through the education system and how we want them to behave. There's the criminal justice system if people commit serious crimes, but beyond that, there's not many. And obviously for migrants, when they arrive, they're generally not going to go through the education system. So what do you think about the idea that actually in Britain currently, the route to settlement is just wait out some time, pay some money, don't commit a serious crime, and you've got it. And actually this is an opportunity for a government in the 21st century to be more sophisticated in saying, yeah, there are some things we want to see people doing that we positively see, and we won't punish you for not doing those, but we will give you advantages if you do that, like contributing to your economy, like speaking English, like integrating. What do you think of that hypothesis?
Could I just jump in first? I hope you don't mind.
Mm-hmm.
I think there's a little bit of lack of knowledge out in the public about what exactly migrants need to meet in terms of criteria for indefinite leave to remain. It's not actually that simple. Each route has specific criteria which you have to meet, which might be going rates, salaries, or it might be innovation. If you're on an innovator visa, if you're on global talent, it might be earning certain income in the UK. They all also have a requirement not to be absent for more than a certain number of days outside the UK over the 5-year period. They also have an English language requirement, which is B1 at the moment, which is quite high, so don't forget that. They also have to pass a Life in the UK test. We have clients who can't pass that because they don't have enough time to actually read the book because they're so busy working in their sponsored skilled roles. But it's not that difficult. So there's something to be said about the fact there are already criteria which people have to meet, and it's not just a tick box exercise. And in some cases, it's quite difficult to meet those criteria. So if you're on an innovator visa, for example, you have to show you've employed lots of people, that you've registered patents, all sorts of things. So each route has separate criteria, and it is not that simple to get indefinite leave to remain. I don't think people understand that. Adding extra layers of complexity on top of that might make some people happy, but it's not really going to solve the issue, which is that there are already people on a route to settlement where there are quite strict criteria that need to be met. And if you don't meet them, you can't get settlement.
I mean, I would just add, I think some of this is sort of a little bit what I said earlier. It's about where do you sort of draw the line. So on English language requirements, I think you can say have those as higher or lower. I mean, personally, I think, having a requirement for settlement, which is that, for example, when you're interacting with the state, you don't need to use translation services and things like that. For most people, that's not an unreasonable requirement to put on people to be a settled person in Britain. That's actually a bit higher, I think, than currently where we are in many cases. But you can also do those higher language requirements at entry in the first place. I mean, that's the other choice that you've got.
Yeah, just to add, if you think about the incentive effect, right? If you have if the bar is very low, then obviously there isn't much incentive because it's very easy to meet. If the bar is too high and people think it's unachievable, then there isn't an incentive there either. So in theory, you're trying to find some middle ground that people can actually aspire to reach. If the goal of this is to create an incentive for integration. I'm struck by the fact that if you look at Table 2 in the consultation document that has the criteria that then reduce your pathway to settlement, they are the volunteering thing, which I'm sure we'll talk about, which is going to be quite messy to implement, is an exception. But for the most part, they are not things that people actually have that much control over. Certainly once they've arrived in the country. So they can't. A lot of people would love to earn 50,000, but they can't just magically say, "Well, I'm going to start earning 50,000 now." They can obviously control language, but interestingly, there are very few points. And language is we know that it's very important for integration, but it doesn't get many points in the table. It doesn't give you much of a reduction. The thing that I think is the single biggest change probably actually is the mandatory work, the fact that everyone would have to work, including dependents and family members and so forth. And I think that is a big deal and will have a big impact. The incentive effect, I think, is tricky. So in theory, you would expect that to effectively forces people into the labour market, assuming that they are actually employable and can find a job. Otherwise, the threat is that they effectively are permanently in a temporary status. So that is a very big incentive effect. Interestingly, so Denmark introduced a similar requirement, and the research on Denmark is slightly mixed, but perhaps surprisingly, doesn't seem, there's one study that looks specifically at the work requirement, which doesn't seem to have had a big impact on increasing employment rates. And one of the reasons that the researchers hypothesized was that people were discouraged, that basically people felt that it was unachievable to have that, such a long period of work. And so then they sort of gave up on the idea and then were discouraged and so felt less integrated because they didn't think they were going to get to permanent status. Now, I don't think that's necessarily exactly how it would go in the UK, and there are different studies that find different things. But I think you think there's a balance between the sort of incentive effect of sort of trying to encourage certain kinds of behaviour and then creating the impression that someone's just never going to get settlement, which can have a negative impact on integration.
Thank you.
And can I just also add that the language requirement for those coming into skilled worker roles is now B2, so it's pretty high. It's university entrance level, and that's the position now. So that's already been changed.
In some of our previous sessions, we'd heard that even with the 5-year time limit, people were not applying for permanent settlement at 5 years. It could be much later. It wasn't the priority. Is that still the case? Because that the implication was extending the length of time might not have that much impact, as people weren't applying at 5 years anyway.
We see in the data people are applying after 5, 6 years mostly. Yeah.
From our perspective, everybody applies as soon as they meet criteria.
That's helpful.
But can I just add, there is good data, the migrant journey data, would actually give you an answer to.
Go to the Migration Observatory website. Has a nice little table showing exactly when people apply.
Thank you. As I say, it was something I think we'd had in one of our briefings at some point, which did seem slightly odd. The other question is around the impact on the UK economy and government finances. What evidence is there of what these changes might have on that?
I think on the overall economy, it's kind of not that much, probably. In the big scheme of things, this is not that big. It matters a lot to individuals, but in the economy as a whole, not that much. On the public finances, it's potentially a bit bigger, I think. But that's, I think, mostly from the sort of, and the single biggest group that I'm sure we'll talk about is sort of care workers who were admitted in the past few years, but will no longer be. So in some sense, they were sort of a legacy group rather than an ongoing issue. So I'm not quite, just to give a specific example, if you think the salary threshold for the skilled worker visa now, where it is, which is 41,700, is it? Yeah. I can't see much point in having this extra higher 50,000 in there, because whether people are eligible or not for welfare benefits at that level of household income, they're not going to get any welfare benefits. So that extra 50,000 doesn't really seems to be adding complication. It means that gives a positive incentive to employers not to give their workers pay increases, which I think is extremely undesirable. So I would be inclined to say, yes, we have the salary threshold for the skilled worker visa, and as long as you've been in line with all of that, the settlement after 5 years at the moment seems entirely reasonable to me.
How does that incentivise them not to give a pay threshold? Sorry, I'm not following.
Okay, because if you say you push your worker over that threshold and they apply for get settlement, they're then free to quit in a way that they're not if they haven't got the settlement. They can get another person to sponsor their visa, but that's obviously a bit harder. So it creates a positive incentive to suppress earnings.
Madeleine.
Thank you, Chair. My question's to Nicolas. I'm a Member of Parliament for Dagenham and Rainham, and since this has been announced, my inbox is full. So I just wondered, do you think it's usual for the Home Office to, which you alluded to earlier, to make changes of this kind on an existing immigration route? And in the kind of emails that are coming in, it's the sense of fairness that is the big issue, I would say. So do you think it's fair to do this, to change the requirements?
I don't think it's fair. It might not be illegal. This is the issue, and I think the government will no doubt rely on the fact that legally they might be able to do this, but morally I think it's not fair. And also, I should say that in the past, the government and the Home Office have changed the rules for existing visa categories, but in most cases, people on those categories have been grandfathered in. So they have been allowed to stay on the same conditions that they entered in until they get settlement and meet the criteria of settlement, which were those which applied when they first entered the route. That has been the case for most of the big changes to immigration routes, and changes to settlement periods, particularly, which have been increased, say, for spouses. For the probationary period, it used to be 1 year. It then went up to 3 years. It then went up to 5 years. It went to 2 years and then 5 years. All of those changes were applied without applying them retrospectively. So people already in the route would still qualify within that probationary period. There's one exception to that, and I should say as well, we've had lots of immigration routes that have been closed. So the entrepreneur route, the Tier 1 general route, the investor route. But all the people on those routes have been able to finish their period to get settlement with some sunset clauses, so a sort of end date when they have to get settlement by, and some of those still exist. So the investor visa, for example, the sunset clause is not till 2028. But the one exception to the changes to settlement periods was 2006, when we saw the increase from 4 to 5 years for everybody on long-stay visas. And that was the one that caused the big furore over the highly skilled migrants, who then challenged the change of the policy in relation to their specific visa category and were successful on the basis of legitimate expectation. But those changes did apply to people already here who had to then do an extra year. And there was a lot of discussion at the moment, at that time, whether that was fair, whether it was in line with Britain's position as a sort of fair play country where the rule of law applies and legal certainty is guaranteed. I would say the government at the time came in for significant criticism. They tried to reassure people, saying there were lots of concessions and things so that people could adjust to move into this 5-year period. But it was a bit of a mess. It was a real mess, and I expect that if these provisions are applied retrospectively, we may see lots of legal challenges. But a very long answer to your question, no, it's not fair.
And can I ask, do you think there's any particular groups that you think will be particularly disadvantaged?
Yeah, so I think, clearly anybody who's on a sub-RQF 6, so anybody who's on a medium or low-skilled occupation who's going up to 15 years. We also have lots of dependents of people who are on skilled worker visas, who may not be working, may be looking after children. We have people on spouse visas, people married to British citizens or people settled here. We're told that the consultation won't apply to spouses, but I don't think that's quite correct, because the way that the consultation is drafted, there are mandatory requirements, and spouses of British citizens may have to meet the minimum income threshold in order to qualify within the 5 years, as well as meeting multiple other requirements on finances and cohabitation and so on, and English language. So I think the particular cohort that will be affected will be those on medium, low-skill visas, spouses, dependents, and obviously children. We're expecting, probably there's some questions a little bit later about children, but I think we would think that children are going to be really badly affected, because having one member of the family not being eligible for settlement will cause untold damage to the children, because their status is dependent on both parents getting settlement, and they can't get settlement without that, which then blocks their avenue to education, access to university with home student fees. So I think children as well are going to be...
And you're right, we are going to have some questions specifically on children later.
And finally, do you think that there should be some transitional protections put in place? And if you do, for whom and for how long?
I think that the issue around transitionals, the way that the government sees it, and the proposal seems to suggest that there might be some transitional provisions for those who fall, what they call borderline cases. So this might be somebody who's eligible for settlement the day before the rules come into place, or who might have applied for settlement and the rules change while they're applying. I don't think that's going to help at all if everybody is subject to this being applied to them retrospectively. So my own view is I don't think any of these provisions should apply retrospectively. If they are going to apply retrospectively, then there will need to be some very clear guidance about who will not be affected and who may be able to come out and get settlement if they're almost there. Because you can imagine there's going to be tens of thousands of people who will be affected if the thing comes in the day before they're eligible to apply. And, I can't imagine how those people would feel. I don't know how your constituents would feel in those circumstances. And that is the problem, always the problem of applying these rules retrospectively to people already in the UK.
I just wonder if the other panel have any thoughts on the fairness and the retrospective.
I mean, I just, no, maybe one observation. I mean, I think it's not a good idea to get a reputation for unpredictability about rules, so predictability is a good thing. I'm not sure I would say I would never do it. I mean, I think it's relative to the size of the problem, and I think the issue here is around the hundreds of thousands of care workers, really, which is a much bigger scale problem than, for example, the highly skilled migrants 20 years ago. So I think, is it absolute, or does it depend upon, what happens in the alternative scenario?
Yeah, just to add, I think quantitatively the largest group affected are the people affected by the mandatory work requirement. So if you think about, you've got family members of British citizens who are already here. You've got hundreds of thousands, and that's sort of maybe 350,000 or so. You've got hundreds of thousands of people who are dependents of either skilled worker or health and care workers, and then you've got British nationals overseas. So those are all quite big groups. And the evidence we have suggests that somewhere between a third and half of the adults in those groups are not working. So I think that single measure, in principle, affects hundreds of thousands of people. And then obviously that will, even for those who can go into work, they would have to do it for a number of years. And so that then sort of pushes back the settlement horizon for them. And then there'll, of course, be people who find it harder for whatever reason to go into work. So I think that's probably, for me, that seems like the biggest single measure in the proposals. But I agree with Alan that I think aside from the mandatory work requirement, the largest one is care workers in terms of the numbers of people affected.
Ms. Murray.
Just thinking about people who come from overseas to work hard in our public services and then find the immigration rules have shifted around them, what do you think is the risk of another Windrush scenario with these changes?
Can I just jump in there? I think there is a risk, and I think it's a real risk. Keeping people on sponsored work visas for endless periods, up to 15 years, and requiring them to stay in sponsored employment, and not allowing them to have periods out of work, which seems to be what is being suggested, it runs the risk of those people who are either lose their job or unable to work and fall outside the sponsored work system, then falling into irregular status. And trying to regularise that status is going to be difficult because you'll have overstayed. You will then be subject to a 20-year route, according to these proposals. So it causes all sorts of problems, and it causes problems for children, it causes problems for families. So I think there is a risk. I think that the risk can be mitigated in a way because we know who these people are, we know where they are, we know what they've been doing. If they don't renew their visas, can we track where they are? Whereas I think before with Windrush it was a slightly different situation where people are arriving and being landed as settled people over a long period of time and staying here, being treated as British people. So it's a different thing, but there is a risk, I think, of people falling out of status, and you're just making that bigger and bigger the longer they have to wait till settlement.
Just to add on that point, if you look at the existing 10-year route to settlement under the family and private life routes, there's a surprising phenomenon where a lot of people entered that route and not that many people are coming out on the other end. If you look at the number of grants of settlement to people on the 10-year routes, they're very small compared to the number of people who went in 10 years previously. Now, we don't know how many, some people may have left the country, although this is a group of people who tend not to for the most part. So I think there is this open question, and it's not entirely clear why, but people, there is reason to believe that people are falling off the longer routes to settlement currently.
Thank you.
Princely.
Morning, thank you for coming. I'm Peter Princely. I'm the MP for Bury St Edmunds and Stowmarket. Before I did this job, I was a hospital consultant. So I'm interested in what the effect of this is going to be on healthcare workers and also care workers. And I think for those of us of a certain age who've had parents perhaps that have been in care, we're all aware that many of the care workers have come from other countries. And this is true in all countries, actually. Now, what I'd like to ask, I think perhaps Alan first, is what do you think the implications are on primarily on care workers for this settlement change?
Well, I think if it's changed, there are two things that will happen. Is that they will, be sort of stuck within social care for longer than they would otherwise be. We know there have been quite serious problems with the way that some of these workers have been treated by some employers, so it's going to do that. They will also not be eligible for, welfare benefits. They're pretty low-paid workers on the whole. A Brit earning that much would, often be getting more benefits. Some care workers came in with children. Obviously that's not possible anymore, but there are children. Those children would be growing up in probably some of the poorest households in the UK. So I think that's the sort of the consequences for them. If you look on the other side, the consequences for the government, if they are given settlement, it means sort of two things. Firstly, there's this eligibility for welfare benefits. That potentially can be quite a large sum of money for the government at a time when it doesn't feel it's sort of flush, basically. And secondly, it gives them the freedom to change employers. And it's quite likely that in that situation, many care workers will choose to leave the care sector for exactly the same reason that the Brits, don't leave the care sector, namely paying conditions are not really attractive enough. And that's sort of what happens, Canada with its caregiver visa, 10 years after entering as a care worker, 10%, 15% are still working as care workers. So I think those are sort of how I would see, the trade-offs in this question of whether they should get settlement on the existing rules or go to something else. 15 years strikes me as a very long time to wait. So even if you were to lengthen it, it wouldn't necessarily have to be to 15 years.
Essentially what we'd be talking about are tied workers. Am I correct in that? So you tie a worker to a low-paid job for 15 years before they're entitled to go for settlement and citizenship, which seems to me to be an enormously long period of time, especially in a situation where we're very short of care workers. So the net migration, I think, came down from nearly 1 million to about, I believe, 200,000 or so last year. So do you have a sort of ballpark figure in your head of what the number would need to be for us to sustain our care sector? Or are we at risk of having a care sector with no workers?
My view on the care sector, the real decision that is are you going to pay these workers properly, offer competitive pay conditions, yes or no? If you say no, you're going to obviously save the government money. You're going to have to use migration. That migration, I think, is going to have to be essentially temporary migration. That's what other countries, do in that scenario. If you say we're going to pay them properly, then there are lots of people who are able to do this job. It's that they don't want to do this job given paying conditions. I don't think you need a visa then, just in the same way as we don't need visas for supermarket workers and so on and so forth. So I think what we've had, unfortunately, is something that is a bit between the two, falls between these two options, and that's sort of why find ourselves in quite a difficult situation.
It feels like we're not really going to solve a problem. That's how it feels to me. So perhaps to Dr. Sumption, the political problem that there is in the country, I think, is that people see these boats coming over and they see these migrant hotels filling up. So do you think that the changes that are being proposed are going to affect any of that?
I don't think that the settlement changes won't necessarily affect the number of people coming in small boats. Obviously, there are specific, there's the proposal for people who've then entered the country illegally to have a much longer route to settlement, which could, in theory, have some impact, but to be honest, I wouldn't necessarily expect it to have a very big impact. Particularly, you've got some groups of people who are coming over on small boats who have already been refused asylum in Europe. They have no other options, right? They're not choosing between multiple countries. They're coming to the UK because they've already been refused elsewhere. And so if you think about people in that type of situation, a 30-year route to settlement is the only thing on the table. So I wouldn't expect there to be a big impact on small boats. Can I just add something, a technical point on the 15-year route for care workers? And this also applies to the other middle skilled jobs where you've got a route that's been closed, and then this is just a legacy. You've got this cohort of people who are in the UK. There's a challenge if they still have to be with a licensed sponsor. We may over time see a diminishing number of these sponsors, right? Because employers won't have an incentive anymore to become a sponsor as the number of care workers. Currently, there's still an incentive to be a sponsor because there are quite a lot of displaced workers, they're international students. Over time, then towards the end of that 15-year period, it becomes increasingly difficult for people to switch jobs because there just are not going to be as many licensed care employers. And so I think there's a technical question about whether the government wants to do anything to try and increase mobility. And the government has no reason to keep people with the same employer. That just increases exploitation, right? They may want to keep people in the care sector, but it may require some thought as to how to make sure that people can still move around between jobs.
See, I'm worried that we'll run out of care workers. We've introduced some changes which are designed to lower the incentives to come to this country, but we might actually end up with not enough people to look after us as we age. And the other thing that, following from what Margaret had to say, is that there are definitely groups of individuals coming to see me who are very worried about the change in the length of time. They're already in the system. They're nursing assistants, actually, and they were expecting to get citizenship and indefinite leave to remain at time X, and now they suddenly see that disappearing into the future, and they feel massively betrayed, actually. And these are the people who are actually the main workers in our care and hospitals. So I'm worried about that. Do you have a worry about that too?
I think that comes back to the fairness discussion. I guess it's a fairness question and then it's a reputational discussion that we've discussed.
It feels like changing the rules in the middle of the game.
And the other issue is to do with the care worker visa itself. I mean, the way the policy was designed, pushed by the Department of Health, sort of forced on the Home Office, very badly designed, no assessment of what the demand was in the market, no setting of quotas, no controls really, and very lax enforcement and oversight by the Home Office. So we've ended up with a very poorly designed policy which allowed a lot of people in, and now those people who came in because they were invited to come in by UK employers are being punished for it, and I don't think that is fair.
In a situation which, as Dr. Sumption said, isn't actually probably going to do nothing about the main political problem, which is that there are people who are desperate coming across on boats. Thank you. Yeah.
You want to add anything?
Yeah, I was just going to say on that, I'd go back to something I said earlier, that actually, although it's totally understandable that people who came in the expectation that these were going to be the rules are incredibly upset about that, whether going forward this affects our ability to recruit workers, I'm more sceptical. If you look at the overproduction of nurses in the Philippines, for example, they're just so, there's so many people who want to move to a country like the UK. Their tolerance for poor conditions, I'm afraid, is quite high.
But just because they have a tolerance for poor conditions doesn't mean to say that we should be tolerating poor conditions.
No, that's the moral issue of it. But I don't think the practical, means we're going to be unable to hire people is quite right.
Madeleine.
Yeah, we had a trade union day where the care workers were invited in to meet MPs. And what come over very, very strongly was at the moment, a lot of these care workers are sponsored. And if you have a rogue employer, to put it mildly, they are more or less saying to the care workers, well, if you don't like it, go. So following on, putting aside the sense of fairness, a lot of care homes are privately owned. It's an employer at the end of the day. And also as well, that you know, if you're going to have work, it's hard work in a care home as well. So do you think that further up the line, when people are not going to come, that's how I see it possibly with the care homes, do you think that that's going to have to be looked at again, sense of fairness aside, economically, because we won't have anybody to look after our elderly and people that need care?
I mean, I think it's been, you know, basically universally accepted that social care, the funding, the paying of the workers is a mess. It has been for a very long time. And given ageing populations, you know, and so on. I mean, my view is that we just have to pay care workers properly. And then all of these problems actually wouldn't really be there. The problem is we know that that is going to cost the government money because, you know, most of the fees are coming from the government ultimately. Obviously, the government is talking about, through the Fair Pay Agreement, putting more money into social care, but they've talked about an outer envelope, I think, of 500 million, which I just don't think is enough. And I suspect if you talk to the workers, they're more interested in the money in their pocket than the process by which the pay was determined. So I think you know, just, you know, government after government has failed to bite the bullet on this, which is pay these workers properly.
And there's presumably a real risk of genuine, very, very abusive exploitation of tied workers who are unable to move to a new employer.
Yeah, I mean, personally, I'm not in favour of tied visas in jobs where the primary reason for the shortage is that their pay and conditions are uncompetitive. That it's not that we're short of people who are able to work in social care, we're short of people who want to work in social care.
Can I just add one thing, just to expand this a little bit beyond the care workers, because this will also impact anybody who's in a medium or low-skilled occupation, and there are all sorts of roles that people are doing. Our experience is, certainly in those roles, more than the highly skilled RQF6, the sort of degree-level roles, finding a new sponsor if you're made redundant, there's an economic downturn, you have an abusive employer, is actually really difficult. And that's because if you go on LinkedIn or any job site, you'll often see that it says, we do not sponsor roles in this company. And you know, it's quite tricky, it's quite difficult to find a new sponsor because of the cost of sponsorship being very high, the additional compliance obligations that employers take on when they become sponsors. So if you fall out of skilled work, out of employment, going back into it can be really difficult. And if that break is going to cause a problem with your eligibility, if you're 12, 13 years down the line and you're almost at the 15 years, you can just see the problems that's going to cause, again, to your point about people falling out of status. And the other thing is, previously, this was less of a problem because the Home Office would take about a year to curtail your leave once they were notified by the employer that sponsorship had ended and you left. And so you'd have plenty of time to find another job and maybe find a sponsor who was willing to take you on. And you will still have status because you still have permission to be here while that was going on, until your visa was curtailed and shortened down to 60 days. That is now happening much faster, and we're seeing decisions coming out very fast from the Home Office because it's being automated. So as soon as the employer notifies the Home Office through the sponsor management system that an employment has come to an end, you might be receiving a curtailment notice, reducing your visa from the 2 or 3 years that's left on it down to 60 days. So people are really in a race against time to try and find a sponsor, and that is often not possible. And to Madeleine's point about there being less and less sponsors, particularly in the care sector, again, that could really be a challenge for people who are trying to find another job. And that needs to be looked at if this is going to come into force, as is proposed for 15 years. We can't really have a system where people are racing to try and find another job and then being penalised if they can't.
Nicolas has got more questions in this area, I think.
Thank you. There's a certain cynical logic, though, isn't there, to the 15-year rule? Because if we're stopping care worker visas, we're tying current care workers into this sort of indentured employment for that 15 years, because with incentives for their salaries to be increased so they don't break free from the system earlier. That is the logic of the system, presumably, and that's what's actually playing out here, isn't it?
I mean, I think there is a tendency for, employers, some employers, like these tied visas, because it gives them more power over their workers. I think that tends to be more of a problem in lower paid roles, who, I think there are a number of reasons that they're sort of a bit more vulnerable to this. Often they are, most of the workers, so there aren't any Brits sort of around, co-workers keeping an eye on them. They may have language issues more and so on and so forth. But I think, so that's the downside of tied visas. The plus side of tied visas for work migration is that you've got an employer who's sort of putting their money where their mouth is. They're saying, I think this migrant is worth, so many thousands of pounds. And that sort of takes up the burden of selecting what sort of migrants we want off the government and onto employers. So I think they're trade-offs.
Yeah, I'm not talking about the employer, I'm talking about at the government level. Yeah. Isn't the 15-year rule a way of maintaining those who've come in on care visas staying in the sector? Well,
It could be, and that could be part of the intention behind the proposal, but that's not made explicit in the proposal itself.
That is the logical outcome of what's happening, isn't it?
I mean, except that I think some of the public sector work, it's not just public sector, this is private sector, and actually I think the proposal envisions for some of public sector workers actually a faster period to settlement.
Only if they're at a higher quality level, isn't it?
I thought we have degree RQF6.
RQF6, yeah.
Yeah, so it doesn't apply, does it, to those on care worker level? No.
I think one of the main goals, and from a policy perspective, one of the main benefits of the 15-year route would be to keep people in the care sector. Obviously, there could be some deterrent effect. If you've got an international student who came here and did a master's in computer science and then switched into the care sector in order to get settlement 5 years later, and they're currently 1 year in, it is plausible that some of those people will just say, I'm not going to do this for, equivalent to, half of my life again. So there could be some negative impact on retention for certain groups, but I think probably on net it does, in the short run, increase retention of that cohort of workers in there.
I'm not defending it, I'm just saying that seems to be a policy goal, it seems, lurking there. Moving to those on medium-skilled workers, you've made the point you don't think the 15-year, extension of 15 years will actually act as a disincentive out there in the world market. What are the problems, or are there any problems in extending to 15 years, the qualification period?
Can I answer that one? I think the issue around medium-skilled jobs, it is all based on what SOC code or SOC code you selected when you sponsored the person. And I'll give you an example. We act for a large group of hotels that has a very big hotel in London, in a very prestigious part of London. The general manager of that hotel is paid a lot of money. But because he's managing a hotel, you look at the most obvious SOC code and you say, oh, he's a hotel manager. And because you don't really care about whether that's RQF 6 or below, that's what you give them. So that person is now on a 15-year track, even though they're doing a highly paid job, managing 500 people and a very significant business, essentially, where they could potentially have been put in at a higher SOC code had we really been bothered about it.
Does that matter with the salary? Because it will come down with salary. So
the salary will reduce it, but the person would still be increased to, say, 8 years to settlement. So it's still a much longer period. And if they were earning, in this case 8 years, if they were earning less, it would be 10 years. So you're still doubling the period for settlement for some of those people. So you have to recognise that these, what we call medium-skilled roles, some of them are quite well paid, they're quite skilled, and trying to put everybody in this sub-RQF pot is not great, because it'll affect everybody in that pot, including care workers and people like this individual who are highly skilled, but when they came in, the issue wasn't really about what their SOC code was. They just wanted to be here and do the job, because they wouldn't have been able to predict that this would have happened. And again, this goes to our point about the retrospective application of these rules.
So there's no way to retrospectively change the coding?
Well, the person could do a change of employer application and move into an RQF role, an RQF 6 role, but then they'll be starting another 5-year track. So again, these are things which our clients are asking us about, and we're saying, well, hold on, we'll just wait and see what is going to happen. And there's a cost to doing all of that every time you do it for the employer. So we expect to see a lot of movement, because people will be maybe doing jobs which could be defined as RQF 6, but it's just going to clog up the system with unnecessary applications, increase costs for employers and employees. Our view is that this doesn't really work, because it covers such a different, wide variety of people. If what you're trying to do is attack care workers, which I don't think is right, the knock-on effect is you're hitting a whole load of other people. So I don't want to create divisions between different types of workers and have different groups pitted against other groups trying to fight for things, which I think is possibly the outcome of this, is really not very welcome.
Yeah, I think this is one of these cases where it's really important to work out what is actually the goal of this, right? If you're looking outside of the care sector at the 15-year route for the RQF 3 to 5 roles, if the goal is fiscal, if it's basically saying we're worried about the possible effect of paying welfare benefits to this group of people or no longer having their immigration fees, then it's not clear why we would care about the RQF level of the occupation independent of their salary, right? So the highly paid hotel manager that, in Nick's example, would comfortably have a positive fiscal impact. And so in some ways you don't need really to worry about the RQF number, unless you think there's some kind of enforcement issue about, if you think that salary is less enforceable than
can you explain that to me again? Sorry, take me through that
So
again.
if you've got so the fiscal impact really depends on how much someone earns.
Yeah.
Depends on whether they continue to be employed and how much they earn. And that doesn't depend on whether their job is classified as RQF 6 or RQF 3 to 5, which is just a
Doesn't the salary one bring it down? Does the salary reduction does allow, or the high salary reduction of time does address that issue to an extent, does it not?
But from a higher baseline.
Okay.
So they would still have
right.
say the hotel manager earning 80,000 would have a 5-year longer path to settlement than a sort of software programmer earning 80,000, even though their fiscal impact
3 year longer. It comes down by 7 years, doesn't it?
Well, no, it depends. In our case, the hotel manager is paid more than 125, so it comes down by 7 years.
Okay.
So say it was 80,000, it would
come down by 5 years. You'd have a 5-year difference. So if it's fiscal, it's not clear that you need to worry that much about the RQF levels. If, however, the goal is to keep people in a particular kind of job, as we talked about for the care sector, then maybe you do want to distinguish. I guess particularly once you get into these private sector roles, the RQF 3 to 5, construction, hospitality, all of these different jobs, it's not actually clear that there is a policy objective, or there should be a policy objective of keeping people in those jobs, right? So Ryanair hired more than 1,000 people as air travel assistants. Do we care if they stay working for Ryanair or if they go do something else? One of the main reasons that people change jobs is to have something that's better fit with their skills, or to earn more where they will then pay more tax. So I think there could actually be a negative impact of keeping people in their jobs, if they're jobs that we don't actually really care if they stay on or not.
Is there is it logical or practical to separate indefinite leave to remain and the sponsorship process? Could one have a system whereby those without indefinite leave to remain didn't require a sponsor if they got another job, or is that totally impractical?
You mean if someone had a temporary visa, they don't have to remain sponsored for that whole period?
Let's say the example of someone made redundant, rather than looking for another sponsor, simply being able to go to another employer, or does that just simply make no sense in reality?
No, you can do that. Sweden does that, actually, for its temporary visas. They have an initial sponsorship period, and then after that, workers can move around even though they don't yet have permanent status. The trade-off there is just that, obviously, the Home Office loses a lot of control once there's no longer sponsored. The sponsorship is the mechanism that enables the Home Office to see what someone's doing, how much they're being paid, etc. So if there's a requirement, if you just say people can actually go and do anything they want, then obviously there wouldn't be a compliance issue there. If you say you have to stay in the sector, but it doesn't matter if you're with an employer who isn't licensed, then that would be beneficial for the workers, and that you would inevitably lose some control about whether people are actually doing that.
And what if it was involuntary leaving their employer, the redundancy example? Could you just allow it for that?
It's a little complicated then when you're trying to look at the reasons. It's probably not impossible, but I think it would be trickier operationally and from a compliance perspective.
Why?
Well, because then you have to know why someone left their employer, and the employer then will have to say this is why the person left. Well, in different cases, the employers may or may not have an incentive to say.
In the example given of redundancy, surely the employer would just say this person has been made redundant. They now can go into the job market. Why would that be so difficult?
I mean, it's possible to do it. You just need to change the whole system. But the issue is, imagine you're in a sponsored visa and you say to your employer, I'd like you to make me redundant because that will give me free access to the labour market. Can you do me a favour? Okay. So there is some scope for abuse there, but it's perfectly possible to design a scheme where if people are made involuntarily redundant, they might be given a longer period to find a new job, a new sponsored employer, or to be given access to the labour market. I don't suspect that will be an option the government will be looking at because they're very keen to control all of this. Because they're very keen to control all of this, as Madeleine said. So I think unless you get to the end of that period and you meet the criteria for settlement and you can leave sponsored work if you want to, or you still remain with the same employer but you're no longer sponsored once you get to settlement, then you'd have to design something entirely different, which I think would be quite complicated to manage.
Thank you.
Can I just check about the impact potentially on workers in roles essential to the UK's industrial strategy? Has anyone looked at any short and long-term impacts on that?
Well, the tricky thing here is that we don't actually yet know what's happening to the temporary shortage list. So the temporary shortage list is designed, obviously, to allow immigration in those roles. The government has not yet said whether they expect those visas to be strictly temporary or not. The time on the list is supposed to be temporary, but and some of the language implies that there might be no route to settlement at all, but instead it might just be a sort of time-limited, maybe 3 to 5 year visa. But I think without knowing, and those are radically different options, right? So 15-year, will it have a 15-year route to settlement like the RQF 3 to 5 jobs that we've been discussing? Will it have no route to settlement? And I think it's quite difficult to comment with so much uncertainty about what's actually going on.
Yeah, can I just add, I think if you actually look at the people who came in the medium skill jobs, what jobs they're actually doing, it's actually a surprisingly small number that you might think are connected to the industrial strategy. I think the biggest group outside social care is chefs, for example. I'm not sure we think of that as part of our industrial strategy. So I think that sometimes this is a little bit sort of exaggerated. I mean, even when construction jobs were eligible, we didn't really see much use of it because it sort of doesn't, the employer sponsorship model doesn't fit with the sort of construction, lots of subcontracting, lots and lots of self-employment, for example. So I'm not sure the proposed changes make that much difference to this. It's more about the temporary shortage list and how that works.
And bear in mind as well that the temporary shortage list, those people coming in since July, it's sort of the scheme has been narrowed so that people can't bring in dependents anymore. So it's looking much more like a temporary a visa than it was previously.
Thank you. We're going to move on to children and families, and Chris Murray.
Thank you. I want to ask broadly, what do you think the impact of the proposals in the consultation will be for children and young people? And yeah, what do you think the impact will be on children and young people, and how do we need to be thinking about this?
So it might help if I just explain very briefly how settlement for children works. So I mentioned it before. If children are coming to the UK with families, say 2 parents, there's a couple of children, they're maybe 10, 15, and they're on a track to get settlement after 5 years. At the moment, both parents need to get settlement for the children to be able to get settlement. If those children obtain settlement before they're going to university and they've been living here for 3 years, they'll be eligible for home student fees. So they'll be treated in the same way as British people in terms of paying them just over 9,000, and also will have access to student loans. And they'll, so it will give them great opportunities to be treated in the same way as young people going into further education. If those children, and sometimes we have children arriving when they're much older, so they might arrive when they're 16, 17, and their parents aren't settled by the time they go to university, those children have to pay overseas student fees when they go to university, which can be very significant, £25,000 or more. Some universities a lot more than that. If you're doing master's programs at Oxbridge, it's going to be a hell of a lot more than that. So they're already having a problem because they don't have ILR by the time they go into university. If you start separating out the parents and saying, well, the main worker won't qualify for settlement, or the main worker will qualify for settlement, but the spouse won't qualify for settlement because they haven't met the minimum income requirement or haven't been volunteering, then one of the parents won't have ILR, which means the kids can't get ILR until both parents have it. So they will be stuck in this position where if they're thinking about going to university, access to university may be impossible because they may not be able to afford it, and they won't have access to all the things that British students have. The other issue, which is a big issue, is that if they're still on a visa route dependent on their parents, they have to remain dependent. And that means not leading an independent life, not getting married, essentially not being able to leave home and get a job. And that can be a problem again for those children who are coming in their teens. Imagine if they're having to wait 10 or 15 years, still dependent on the parents getting ILR. What happens to them? And they're going to be on these visas forever. We have some clients whose kids are in their mid-20s because they came they came around sort of 23, they came around just before they were 18. They're still living at home, they can't leave home, and if they don't qualify for whatever reason, they're going to have to continue doing that unless something is done specifically for them, which gives them an independent status where they can get on with their lives. But at the moment, the way the rules are, and the way these proposals interact with the current rules around children, it's going to be a significant problem, both in terms of access to educational opportunities and being able to get on with their own lives and start contributing actually to the UK as independent people who are working.
Thank you. That's very helpful. Can I ask about a different category of children? So this is people who are born to migrant parents in the UK. So just let me check I'm understanding the scenario here. So migrant couple get a job in the UK, come to the UK, work. Both parents are non-UK citizens. They're on a visa route. They have a baby who's born in the UK. What's the impact on that child under these proposals?
The rules on children born in the UK is that if one of their parents subsequently becomes settled, then they're entitled. They have an entitlement to register as British citizens. Right. And that's up to the age of 18 they can do that. If by the age of 18 their parents haven't got settlement and they still haven't qualified for citizenship and they probably don't have settlement either, then the issue of British nationality is a problem because in order to get naturalised as a British citizen, you need to have settlement. And so they're going to be frozen out of becoming British citizens until they themselves get indefinite leave to remain as adults.
Here's a question for you, is I can understand that in those particular cases we're increasing the likelihood that there is a cohort of people born in the UK, living their whole lives in the UK and struggling to reach British citizenship. But I'm trying to understand the scale of the problem that we could be creating here. Even under the long pathways to settlement, that's still 18 years that family has for that person to become naturalised. I understand we're making it longer, but how much do you see, for the whole panel, the challenge of what we really, I think every political party would accept we do not want to create, is a cohort of British people without status, or without full status in the country? Is it a real challenge? I mean, I understand there will be small cases where it takes 18 years for a family to get a settlement. What's your view? Anyone?
I mean, could I say, I mean, I think that generally, I mean, they're dependent on their children, you know, their parents applying for, and I think even under the current system, it's important that these children who basically know nothing other than the UK, you know, have a path to be British citizens. But more than that, I think actually we positively want them, this group, to become British citizens. And so it's not just about having the right. So it's a little bit, you know, even under the current system, I think sort of things like reducing costs for the children and things like this is important. I think even apart from the legal status, there is the question of, you know, the family circumstances that these children may be growing up in. They're maybe in households with no recourse to public funds, with very quite low levels of earnings. These are going to be the poorest households in the UK, pretty much. And, you know, I think child poverty is not just terrible for the children, it's actually a very bad investment for us. So we kind of need to think about that. I think maybe there's a scope for some sort of more creative thinking around here, around, you know, you could have some eligibility for some welfare benefits without necessarily giving settlement, not tying these two things quite as tightly as they are under the current system and are under the proposals that have been made.
Thank you. I want to come back to no recourse to public funds in just a second, but one of the other, just before we move on, one of the other sort of proposals in here is that you would have family members on different routes to settlement. What's the impact of that? And would it be very unusual? Does it happen in other countries?
And could I just say, I'm not sure about other countries. It just strikes me as this is not a good idea, basically.
Why is that?
Because I think it's going to lead to, I mean, Madeleine's already mentioned people who just, for whatever reason, didn't work. Maybe they were looking after children, are suddenly, you know, not going to be eligible. That seems really fundamentally unfair. I'm not sure that the scale of the problem that's caused by sort of treating people as sort of households rather than individuals is actually big enough to warrant this kind of thing. So I just think I doubt it would work in practice. I think you would end up with sort of some really pretty awful cases coming to light, and, you know, it then unwinding. So I just personally, I don't think I would go there.
I think if you have a small discrepancy of sort of 1 or 2 years, like we currently do with the global talent, the accelerated global talent route and their dependents, it doesn't make a huge difference. I think it's when you get these really big discrepancies and maybe one person with basically no obvious route to settlement at all in the household. If you're looking specifically at work visas, then I think it does actually make sense, and you're interested in the economic impact, then it makes sense actually to consider the household as a unit, because they either, you know, they're either here or not here together. And so the economic impact of that family coming to the UK is the thing that policy is influencing. And if you have a highly paid, so if you're interested about the economic, if you look at public finance, for example, and you care about the fiscal impact of a particular household, then it doesn't necessarily matter that much if you've got 2 medium earners versus 1 very high earner and 1 non-earner, right? That if the main applicant is able to pay for the whole household, then from an economics perspective, that's okay. That's actually very different from the situation for when you're looking at partners of British citizens. because they're both migrants. If the goal, and this again, it's unclear what the goal of the mandatory work requirement is, even if you're looking at sort of, say, a skilled worker household. If the goal is economic, then you can just treat the household as a unit. If the goal is something else, maybe it's, if it's social, and the idea is that sort of having non-working mothers, for example, is fundamentally a bad thing, then obviously, the logic would be a little bit different. But I think this is one of the areas where it would be useful to understand sort of precisely what the government's trying to achieve with the mandatory requirement, and that would help them work out how to design it and what exemptions there should be.
Can I just add just one additional point, to your question about nationality? We do actually have, and I should have mentioned this, we do actually have a provision in the British Nationality Act which allows children who are born here to register as British once they've completed 10 years in the UK. So that's quite a useful protection. For those who aren't born here and arrive at an early age, who might be on this very long track to settlement, at the moment we have a long residence rule, which means that if you spend 10 years continuously in the UK, you can also get settlement. But there is a proposal to get rid of that and nothing to replace that. Now that long residence rule has been around for a long time. It's been there to implement supposedly the European Convention on Establishment, which provides additional protections for those who've been here for 10 years, and the UK is a signatory to that convention, which is a Council of Europe convention, and that is being dumped, as far as we can see, by these proposals. So, again, there was a thing for children who might get settlement in 10 years, and other people who might get settlement in 10 years. That's being gotten rid of. So again, that will affect children and other people.
Okay, that's interesting. I didn't know that actually.
What is the policy goal there to remove that rule?
I have no idea. It's a very useful thing that people who've been here for 10 years in a number of different categories, so they might have come as students and be working, or be in different rules, under different rules, but who've never quite made the settlement rule in one category, can actually stay and settled here. But that is going. This is an aspect of the immigration rules I hadn't got my head around. So obviously we've had the 10-year route, right, we all know about. Are you saying there's a different 10-year route for those who arrived as children? No, this is the same.
It's the same 10-year route. It's being proposed to be
long residence rules. Yeah.
Okay, I hadn't clocked the impact on children, so that's really useful. Two more questions. First question is, am I correct in understanding that a child's path to settlement would be dependent on their parents' contributions and earnings, and consistency of earnings? What's the implications of that? How fair is that? Given what we say about, as we just abolished the 2-child cap, that it's not the children's fault what family they're born into, how does this match up with other elements of government policy? Is it too broadly defined a question?
No, it's a perfectly reasonable question. I mean, personally, I agree with, I think, your implication that, to hold children responsible for the acts of their parents seems fundamentally unfair. And I think that, you need something which says that children who have basically spent their entire life in the UK know nothing else. They're British, basically, to all intents and purposes. And they should have that legal status, and that's not conditional on, what their parents have or haven't done. Now, quite exactly how you define how long and so on, I think you can debate, that.
There are already these rules. So you've got the family and private life rules, and the private life rules have there are various different circumstances depending on what proportion of a child's life, or proportion of a young adult's life has been spent in the UK. They may be then eligible to switch into the private life route. Now, assuming that continues to exist in the normal way, you may end up with situations where people then who are in these situations who are dependent on their parents may end up switching into those human rights routes instead, which is not, you may see, I guess you could say that that's a good outcome because you have a sort of another option for those children who end up in these slightly messy situations. Those applications are not necessarily, the government doesn't particularly like them I don't think the government has a particular desire to channel more people through the human rights routes. So I think, in general, one of the things that's sort of mostly absent from the consultation document is just sort of what is actually envisaged for children, particularly the ones who become adults. And how do they move on to an independent status, and what kind of status is it? That's all very unclear from the consultation.
I mean, could I just? I mean, I think the consultation just says we welcome views about children, which suggests that they haven't quite thought it all through, perhaps. And this is obviously a really important question. So when things are apparently being abolished, it may be that it's not an active intention to abolish. It's just somebody hasn't quite thought it through all the implications.
I mean, I would also say this is splitting up families, putting people on different tracks, requiring people to jump between categories, is really going to add masses of complication to the whole immigration system, which, as it stands, is already pretty labyrinthine, and complicated. Even judges dealing with immigration cases can't understand the immigration rules themselves.
And members of select committees.
We have enough trouble as it is lawyers understanding it, but so it really is a really complex system, and I can only see this just multiplying the level of complexity,
And just if I could ask one more question, and I'm sorry to take up so much time, but I want to go into no recourse to public funds, which we alluded to. So obviously this will extend the amount of time people are on no recourse to public funds, and families with children are on no recourse to public funds. But we have other laws in this country, which is that local authorities have statutory duties to provide housing for homeless children, and we won't have street homelessness in this country. What are the implications for child poverty of keeping people on no recourse to public funds for longer amounts of time?
Well, I mean, we know there's quite good evidence to show that migrant families subject to the no recourse to public funds requirements are already often the poorest and in the most difficult situations, and that there are high rates of poverty and destitution amongst children of migrant children and asylum-seeking families. So we know that. There's a lot of research on that. The immigration minister's been asked what's being done in relation to children and the settlement proposals in relation to the child poverty strategy, and that's being looked at. But there are real concerns, obviously, about maintaining that. The other thing is punishing people for having the no recourse to public funds requirement removed seems to me to be utterly mad, because A, it's the Home Office who are giving them permission to access public funds, and B, the criteria for accessing recourse to public funds are really serious. They're destitution. We are talking about exceptional periods where people, for one reason or another, do not have access to income to support themselves and their families. And so to penalise people who've been on, even for a short period, on no recourse to public funds, and then may go back into having a regular visa which is subject to that requirement, again, seems to me to be completely mad. So I think we need to think very carefully about that.
I take your point. I wasn't so much asking whether it was mad or not mad. I was asking what's the impact on child poverty. Will it go up, will it go down, or given we already have statutory duties to protect children, will it stay the same?
I think you'd have to say it would go up, but as you implied, the effects don't appear, are not as large on paper, because there are these other routes by which people get some degree of support. I mean, once people are here, they're sort of our responsibility, whether we like it or not. And so there has been this unfortunate, the central government saves money, but then it puts a lot of more burdens on local authorities, and that's been quite a serious problem. And I can't see that. I can only see these proposals making that a bit worse. I don't quite know how much worse.
Yeah, obviously the threshold for getting support from the local authority is higher. So there would be a group of people who are not destitute but would be in poverty as a result of having no recourse to public funds. I think, as Alan mentioned earlier, the biggest group here is the care workers who came in before the ban on dependence, who came in with children. Because actually, if you're a care worker, particularly if it's a single parent, but even if you've got two people in the household, you can quite easily actually be below the poverty line if you've got children on a single salary of a care worker. Those are people who actually would be eligible for quite a lot of in-work benefits if they did have recourse to public funds.
Thank you.
Peter.
So I'm just sort of listening to this with kind of increasing dismay. So would it be a reasonable thing to say that the proposed changes are likely to disadvantage children, families with children, without having any net effect on net migration or reducing the number of people who are trying to get here in what are called illegal routes on small boats? So are we, in fact, introducing a whole lot of changes, or proposing to introduce a whole lot of changes which are not going to actually help us very much?
Well, it's not clear whether that's actually the goal, though, to influence net migration. And I think net migration is not the only policy outcome that the government might care about. So that even if there's no impact on net migration, which I think is perfectly plausible or a pretty small one, they might want to do it for other reasons, to affect what people are doing while they're here, all of the stuff that we've discussed.
No, I do think there will be effects on what people do here, but the political difficulty for the government is the number of net migrants and how many of them are coming and what routes they're coming by. And my impression is, from what I'm hearing, is that some of these changes, particularly in respect to the families and the children, are going to disadvantage the children somewhat significantly and not affect the main thing that the government wishes to change.
I mean, I think my view is that it might have more effect on the asylum claims than many other people believe, but I mean, I don't think the evidence base is terribly strong. But there's one study that when Sweden moved from offering only temporary protection to Syrian refugees to permanent protection. I mean, that's the opposite of the direction we'd be going, that numbers went up a lot. But the other thing I think is also to think about, I mean, it's really the public finances are in the equation here. So not all of these migrants with no recourse to public funds would be, some of them are quite well paid. Not all of them have children. We might have a different attitude to, somebody who's badly paid, but they don't have children because poverty is bad, but many of us think child poverty is worse. So, so there is, there is a question, what is the cost to the public purse of continuing with the current rules versus changing to that? I mean, I can't give you an actual number for that. I mean, if I was in the government, I'd be trying to work out what is at risk here.
We've got a couple of questions on a contribution-based system. Are you okay to go slightly beyond 11:30? Is that all right? Great, thank you. Paul Kohler.
Thanks. We have this time adjustment model where we have these periods and they can be reduced for certain contributions. On the financial contributions, those earning a higher salary, the logic presumably is people who earn a higher salary are less likely to claim welfare benefits in the future. Does the evidence, presumably the evidence does show that, does it?
Yeah. People on high salaries. It's not clear. The 50,000 isn't really based on, it's based on the tax thresholds, the tax rates. If the goal is fiscal, then that tax rate is not actually the most relevant thing. As Alan mentioned, I think people coming in with the almost 42,000 on the skilled worker route, for example, are already comfortably fiscally positive over the course of their lifetimes. So I think if it is about public finances and how much people are paying in tax and so forth, then I guess the question is why not do an actual fiscal calculation and work out, how much of it doesn't have to be that you're taking people right at the break-even point where they become fiscally positive by £1, but you might have, say, okay, well, we want people to have a contribution of at least X amount, and then just work out what is the amount that would be, because I think the 50,000 is a little bit arbitrary.
And the higher figure, 125,000, how's that been? Is that also another tax?
It's also based on the tax
So the assumption is there's been no such calculation. It's just grabbing figures off the tax code.
I think so.
Okay. If we turn to the non-sort of mandatory minimum requirements, contributions, how practical is using other sorts of contribution to reducing the time limit?
You're talking about the volunteering requirement here. Yeah, I mean, I'm sure Nick will have something to say about this. This seems like the one that's a real nightmare to implement. You obviously, the risk is that you create a cottage industry of organisations providing volunteering opportunities so that they can sign the paperwork, or indeed that if you have charities that charities that are inundated with people who want to come and volunteer, not because they actually want to be there volunteering, but in order to meet the immigration rules. So I think that is very. Anyway, that creates all sorts of risks with perverse incentives. It's a pity in some ways that it's so difficult to implement, because it is something that people control and that is not purely about salary. And I see why the government would want to have some kind of, to include social contribution in there. It's just that social contribution is by its nature so much harder to measure. On the operational complexity point, I would just add there's the salary requirements. I think a lot of this stuff, is perfectly feasible. It can be done in the rules. It can be implemented by the Home Office. Salaries, if you look at the existing salary requirements for family members, which is, comparable to maybe what we will be looking at, right? People have to demonstrate that they've earned, the British citizen sponsoring a spouse has to demonstrate that they've earned a certain amount over, in order to sponsor their spouse. It is overwhelmingly complicated, right? There are pages and pages of guidance on what counts and what doesn't, and exactly how you account for self-employment income and different kinds of employment income, and what happens when the income varies. And it's extraordinary how much detail is required for that. And so I think there is a risk if you're then putting in the settlement system, you've got everyone having to demonstrate their income. Is there going to be any kind of process to try and make that simpler? There are always going to be complicated cases, but is there, for example, what happened with the EUSS scheme for EU citizens, where they were able to automatically pull their pay records if they'd had a sort of straightforward employment history? That sort of thing could greatly simplify things. But I think, as it stands, if people are actually having to kind of submit piles and piles of paperwork to demonstrate their earnings, then that obviously will be quite a burden for the operational people at the Home Office.
On the volunteering point?
Well, I think I probably agree with the National Council for Voluntary Organisations that said it was immoral and impractical for the reasons that Madeleine set out. I think forcing people to go and volunteer, if that's the only way that they can meet the settlement criteria because their salaries are low, is a bizarre thing to do. And because, again, they have no control over their salaries, they can't control that. So, that will be the thing to do. Whereas you've got highly paid people who don't need to do that. So it's to me, it seems wrong. I think the practicalities of implementing are going to be incredibly difficult. We've already had numerous queries about, well, I'm volunteering, I'm doing this. Will that qualify? And we have to say, of course, we don't know. But, there are so many charities that people do things for. They sit on the board of, and some of them might be quite esoteric and, be promoting the work of some composer that nobody's ever heard of. And some of them might be, doing food banks. And so, again, where do you draw the line about what is a charitable organisation that's, doing public good and what isn't? Again, and as Madeleine said, how do you police it? How do you make sure that a charity is not just signing off on people's, hours, saying they've done an hour every weekend for the last 3 years? It's just really difficult, and it puts charities in a really difficult position because they don't want to have people who don't want to be there. They don't want to be policed. They don't want to be doing all this extra admin. If the only reason is because the person can't meet the settlement criteria based on salary, for example. So I think it's not workable. Sweden has, Denmark. You mentioned Denmark a bit earlier. Denmark has a system of people going on, being able to meet one of the additional criteria of the supplementary requirements to reduce their period of settlement from 8 years down to 4 years. But that's tied in with lots of other things that you also have to do in order to get to this 4-year reduced period, which includes, Danish language at a very high level, being employed for 4 years, having a minimum income of about £40,000, so it's a lot less than the 50,000 we're suggesting, and doing all 4 of these gets you down to, including the volunteering, gets you down to 4 years.
So it does work. So a volunteering requirement or option does work in Denmark.
Well, I don't know. We don't know, and we don't know. I think Madeleine mentioned some data on that, but Yeah, I mean, if you see that a way, it's similar that in word or deed supports the fundamental democratic values and legal principles in Danish society. That is the criteria for which the work that you do will be valued as qualifying you for this reduced period. Now, that seems to me to be a very bizarre criteria to apply to volunteering.
Do you have any knowledge of the international perspective?
I don't dislike the idea in principle. Yeah. I just think it's impractical.
Yeah. Thank you.
Thank you, Margaret Madeleine.
Yeah, I'm just wondering, on the planned contribution system, do you think the government is possibly thinking this might help with integration, social cohesion, actually giving the kind of the areas you live in, you're a part of that community and it's more embedded into that? Do you think? I don't know what the panel think on that.
I mean, I think that there are lots of ways of thinking about what social integration is, and these are the types of things that researchers measure when they try and look at social integration are things like volunteering, not necessarily formal volunteering for a charity, but then also being involved in. There's some mention in the consultation as well as being involved in local clubs and other activities. So I think there is, broadly speaking, I think it's perfectly legitimate to say that is a desirable goal. I think it just comes down to the practicalities of trying to then sort of turn something that is very complicated into something. Ultimately, if it's going through the immigration system, there has to be a box that someone ticks, says yes, they did the thing, or no, they didn't, and that's where kind of trying to reduce it all down to a yes/no answer is just always going to be really tricky for social contribution.
Can I ask a tiny follow-up? So my understanding is that if you apply for French citizenship, I may be paraphrasing a bit, but you go to an interview which is in the language, and then you're also asked to describe your engagement with French culture. So I think they ask you about French films and French literature and what do you do in your community, and it's a kind of interview rather than a box tick. Do you think there'd be any capacity in the British system rather than the Life in the UK test, which, as we've discussed, can be a bit very tick box? If you had a bit more of a qualitative engagement with the Home Office citizenship system so that your contribution could be more meaningfully assessed?
That's how much discretion you want in the system, right? I mean, the benefit of the tick box system is it is very transparent. People know what they have to do, and there isn't a concern that depending on the mood of the person that day, one person gets through but an equivalent person doesn't. So I think it is a challenge. You're putting quite a lot of demands then on the caseworkers in the Home Office who are not super highly paid people to then decide who is contributing and who is not. So in general, the Home Office has tried to avoid very discretionary criteria, and except obviously in the cases where it can't avoid them, like in the asylum system and so forth. But it's those ones where you have discretionary criteria, that's where the processing becomes very difficult. You often build up backlogs. It's sort of much more cumbersome and expensive for the Home Office to assess them.
I think it would be a terrible thing to do.
And could I just add that I mean it's the discretion point. I mean, I have an ex-PhD student of mine who's a British-born but Pakistani ethnicity who was working in Paris, was turned down at interview for being insufficiently integrated, even though she was the most integrated person you could possibly come across. So I think it's very time-consuming, and I think establishing consistency of standards is really difficult.
Is there any evidence that it helps with integration?
I don't think so, because you can, you know what you have to say. It's what's in your head you believe. I mean, the Life in the UK test, again, I think is probably more about testing language than anything else. But ultimately, we're trying to, it's what people think inside their heads, and we can't see that.
Thank you very much for your time and for allowing us to go slightly over 11:30. We really do appreciate it. We'll be having another session on this next week, but I will bring this to a conclusion. Order. Thank you.